Good afternoon, everyone. My name is Joe Calabrese. I'm a partner here at Bressler, Amory & Ross. I'm here today with my partners, Sean Coughlin, Angela Turiano, and our mediator, Ellen Slip. And today is our second annual Ethics in Mediation in the World of Zoom. So we had such a success last year doing this. We decided to do it once again, really just to see, number one, has anything really changed? Has it gotten any better? Has it gotten any worse? Have we gotten used to doing this? But more importantly, to make it eligible for that really important one ethics credit that everybody should have at least once a summer, what are the ethics behind it? So that's what we're going to be doing today. As I told you, I'm with my colleagues, Sean Coughlin and Angela Turiano. Our mediator here today is Ellen Slip. A couple of things that are important. We have all worked together before. We're all colleagues from the Brooklyn DA's office. And I have to say that because in that fraternity and or sorority, we always have to recognize where we came from. So it's not, it shouldn't be a shock to you that we all know each other very well and work together very easily, which makes doing this a lot more fun. So hopefully this will be useful for you today. We have, just like we did last year, a hypothetical with a series of questions at the end. We've added polling this year, which means you get to vote on what you think the answer is. We added a game show aspect to it a little bit. I'll be in charge of doing that. I have no idea whether or not it's going to work. We're going to hope for the best. But more importantly, what I'd like to do is get the show on the road. I'm sorry we're a few minutes late today. You can blame me for that because the question really is, are you ethically obligated to understand Zoom? I'm in violation of that ethical rule this morning. We had some trouble, and you can blame me. So I'm going to try to make up the time. So important, if you have questions, we want to know them. We're going to try to get to all of them if we can. What we'd really like you to do is use the Q&A function at the bottom of your screen. That way, if we don't get to you, which is possible because we are really crunched for time these days and we're 5 minutes late because of me, we can get back to you. You're free to do it in the chat if you want to, but those don't get saved by Zoom. All right, so that out of the way, Ellen, I wanted to start with you before we get to the hypothetical. Very interested in your impressions on how the year has gone since we've been together talking about this in the world of virtual mediations, and we'll start with you on what your impressions are and how things are going. So
okay, great. Thanks everybody, and thanks to the audience who has dialed in today. I started my mediation practice about 2 years ago, right around when the pandemic was hitting. And those of you who know me well know that technology is not my strong suit. And the best witnesses to that are my two sons, who used to do all of my PowerPoint polishing up before I had to speak at any city offsite while I was in-house. So it's been a learning curve for me, but you know what? I'm getting much more facile at it. And I think that it's a tool that is going to be here to stay for a very long time for most mediation matters. And, you know, Joe, I appreciated the introduction. And of course, I know Sean and Angela well. Just because we had the same roots in the industry does not necessarily mean I favor them one way or the other in a mediation. I think Sean, Joe, and Angela will say that the pendulum might actually swing the other way because I don't want to be perceived as in their back pocket. And I asked some super annoying questions. So forgive me for that.
You can all testify to how annoying you can be.
Very
Thank
annoying.
you. I consider that a compliment.
Probably testify even better than most of you.
I know.
Ellen, you are exceptionally annoying.
Appreciate that. So I would say, like, when I started this, I did some nascent research on it, and I got published in the Securities Arbitration Commentator on what to expect. In preparation for today, I went back and read that article again, which is on my website, Ellen Slip Mediation, and I have to say it stood the test of time. So the main takeaway from that article, which remains true, is prepare, prepare, prepare. So you don't necessarily have the luxury in a mediation of walking down the hall, photocopying a document, sliding across the conference room table to the mediator to factor in an argument that perhaps wasn't discussed in the pre-mediation back and forth, or wasn't really the focal point of the liabilities and the strengths of the case. So you really do need to prepare and know your documents really well. And you need to make sure that your clients are also very prepared and available. And being available might sound like, are you serious? Like, obviously they're available. They set aside the day. I think in an in-person mediation, availability and presence of mind is a little bit easier to accomplish because they've traveled, they've rented a car, they're in a hotel room, they're in the conference room, either at JAMS, FINRA, or a lawyer's office. So I do find, and I insist upon this, I've got a mediation tomorrow, and I insisted that I have the cell phone numbers of the lawyers and that their clients have reserved the day and are available. As you all know, a lot of the really hard work gets done from 3 to 5, 6, 7, and that's when people start to get petered out and tired. So they really do need to be very much available. So going to the technology, and we're going to noodle this out a little bit more in the hypothetical. The preparation also contemplates really being good at, and this is for practitioners as well as mediators, really good at setting up the breakout rooms, turning off recording. This is recorded, of course, because it's a CLE. Mediations are not recorded for obvious reasons. Knowing how to do the video, making sure that you know how to share screen if there's a document that becomes relevant. Making sure of basic security 101, you have secure passwords and the mediation information, the invite has not been passed around. Now, when I do mediations, I have found that some of the litigants, mostly on the claimant side, like to have emotional support because it's, for many of them, particularly elderly clients, it's a stressful, unknown world that they're navigating. So they might want a family member, a lawyer, a neighbor, somebody to join them. You just have to make sure that those folks, they're not disseminating the Zoom mediation far and wide. One of the very first ones I had during pandemic, the elderly claimant, Mrs. Moskowitz, we'll call her, invited 3 of her grown children, all of whom happened to be lawyers, not securities lawyers and not even litigators, but she thought that would be helpful for her. And net it turned out to be, but for the Respondents Council and for me as a mediator, there were just that many more people asking questions and not necessarily knowing the ins and outs of the procedure. So I don't know if that's my time because
good.
I know we were a little.
That's great.
Okay.
Thanks, Ellen. I want to ask you one more thing before we move over to Sean and Ellen. I'm sorry, Angela. I got a question that says, a colleague once said, never mediate remotely. It's nothing but free discovery. Do you subscribe to that? Do you think that it's just free discovery, or is being in person more
I think
control of the
free discovery, but it's free discovery on both ends. If you go about it the right way and if you're prepared and you raise the right issues with your adversary, you learn more about the case.
And in that regard, it's not necessarily different from an in-person mediation.
Yep.
The same types of questions are raised in person versus Zoom. And, it's just as thorough as you are in your preparedness and knowledge of your case. I had a mediation once where the client, the claimant's lawyer was talking about a husband and wife, not realizing that, the dearly departed husband had passed away a year prior. You got to be prepared and you got to know your case. I think there's always an opportunity for free discovery, but that's the same in a bilateral negotiation, just phone to phone. That's one of the questions I always ask is, where are we in discovery? Are you done? Do you have cross motions to compel? Because I don't want to go down rabbit holes. Time is precious. But of course, it can be an opportunity to learn more about the case, which I think is a good thing, not a bad thing. And I don't think that the advent of Zoom is different in that regard than in person.
Thanks,
I
Ellen.
found,
Angela. Oh, go ahead, Sean.
that people seemed like it's easier to walk away on the TV screen, if you will, than when you get together in person. And I have to say that in the various mediations that I've done over the last year, with the exception of the one that you and I did, I didn't seem to get the same amount of pressing questions and pushback from mediators that I used to receive when you did things in person. And I think that's an important thing. I don't know what's going on the claimant side, but if you're going to try and work for everybody to get to a resolution, I think you need pushback. And I think the mediator needs to understand the Respondents Council and the Claimants Council, understand the case and understand where the pushback's coming, and have considered those issues and know what's going on with their case. So it's really not making those points. I also think it's harder with clients as well, because we've all gone through this routine where we've explained many times the same issues to the client beforehand and talking about a potential settlement. And then the mediator comes in and almost repeats what we said. And the client sometimes looks like us going, I never really thought about that before. So, I miss those in-person sessions with everybody in the room, in the same room.
Yeah, I think that's true. And I have found though that these days, I feel like clients, you hear about mediation, they almost assume it's going to be virtual,
Mhm.
not in person. And I think that there's a lot of benefits to a virtual mediation. And I think they're great for your smaller cases where it wouldn't necessarily be the time didn't want to take the time and effort to like travel to California and do the mediation. But, you know, I've actually been successful in, I think most of the mediations I've done virtually. If not, I think there's one that we were not successful in, but I do think that there is a place for the in-person, but the virtual is a great option, and you can get the same traction out of it. I think it just depends on who you use and whether or not they're using the platform appropriately.
Okay, great, thanks. All right, so why don't we move into the hypothetical? I'm going to make the Herculean effort of sharing my screen. We're going to see what happens.
While you're doing that, Joe, there was a question that came in about how do folks get skin in the game. I think there's a couple things. I think you need to at least have some agreement on where the goalposts are.
Yep.
You know, what the net out of pocket is, if it's an employment case, what the promissory note left less any offsets for counterclaims in. And I tell claimants attorneys and respondents attorneys, but mostly claimants attorneys, just because I'm asking you to agree to a number on a sheet of paper doesn't mean that you can't still convince me that respondents need to pay you well-managed account type theories or return of dividends or the tax consequences, whatever the other issues are outside the NOP. But I think having the parties come to a realistic assessment of what, you know, what the number is really helps people get skin in the game.
I think it's a different way of looking at how you value things. And I think that's something that obviously everybody has to take into consideration. I think it was a good question. I appreciate the answer. All right, so why don't we head over then to our first, all right, so I'm hoping everybody can see that. So I'm just going to read this off and then we're going to start with the panel. You've scheduled a virtual mediation over a business dispute between two parties. Parties to the mediation include your 82-year-old client, because they're always over 80 years old. Her name today is Mrs. Scott, your paralegal, and the respondent's attorney, her client, and the respondent's attorney paralegal. So we have a lot more people involved in these things than we used to, because I think a lot of us need the help to get it done. You've agreed to host the mediation using your Zoom account. That's a huge mistake. Your knowledge of Zoom is superficial at best, but you have your paralegal to help out so you're not worried. She's told you she can handle setting everything up and even managing the breakout rooms, which we'll talk about later, is critically important for client security. The day of the mediation comes, and when you arrive at your office, you find the note from your paralegal telling you that she has joined the Great Resignation. She's quit. She's not coming back. You are on your own with Zoom. So question number one is, do you have an ethical obligation to understand how to work Zoom? And what we're going to do now is, first things first, is we're going to throw a little poll in there and see how many of you actually feel that way. So question number one is as follows. Do you have an ethical obligation to understand how to work Zoom? Well, wow, it's coming up real fast. I was going to say we needed 30 seconds. I don't think that we do.
Oh, panelists can't vote. I just tried to vote.
No, you're not allowed to vote. All right, but I think we have enough to even.
I hate being
move on.
excluded.
No,
It's still
no,
moving.
no.
Joe, it's still moving.
Yeah,
All right, so you want to give it a minute? Go ahead.
71%.
That looks like a nice asset allocation to me, 77-23. Just,
72,
do we
73.
guess that it gets to 100? I don't
and the
know.
poll. We're at
We're having way too much fun.
Yeah, way too much fun. All right, look, it's obvious that most of our participants feel that you do have that obligation. We're going to share the results with everybody. So that's where they are. So why don't we start, Ellen? We're going to go to you. Do we have an ethical obligation to understand how to work Zoom?
Yes, and since we are constrained by time, and I did address it a little bit in my prefatory remarks, because of Rebecca Johnson in Marketing at Bressler, she prepared, which was attached to your invite today, a list of all the ethical references, including the model rules of conduct, the New York rules, and some ABA materials. So for the sake of brevity, the answer is yes.
Fantastic. Anybody else want to talk to us about that?
So just Ellen referenced some rules. So it is true, you wouldn't think, it sounds kind of silly, right? An ethical obligation to know how to use Zoom, but it's really based in a basic model rule, which is competence. And if you look at Model Rule 1.1a, and New York has a parallel rule, it says a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So you may say, okay, well, that doesn't really necessarily include Zoom, but if you drill down to the comments for Rule 1.1, you can see they talk about, in both the model rules and the New York rules, they talk about maintaining competence. And to maintain, which means to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks of relevant technology. And certainly these days, what is more relevant technology than Zoom? And there's more in the model rules, more in the commentary about thoroughness and preparation. But if you don't think the rules tell you that you need to be, you're ethically obligated to understand Zoom, all you need to look at is ABA guidance. They put out an opinion, the ABA put out an opinion in March of 2021, and it was ABA opinion 498. And it's actually entitled Virtual Practice. And the intro specifically states, the ABA model rules of professional conduct permit virtual practice, which is technologically enabled law practice beyond the traditional brick and mortar law firm. When practicing virtually, lawyers must particularly consider ethical duties regarding competence, diligence, and communication, especially when using technology. The opinion goes on to talk about the duty of confidentiality, as well as to ensure not only yourself, but your subordinate, your junior lawyers, and your staff also understand the technology. And the opinion also talks about, which is important, and we're going to discuss later, the understanding the technology so much that in order to guard against inadvertent disclosure of confidential information. And we're going to talk about the inadvertent disclosure a little bit later, but to the extent anyone had a doubt, I think all these rules in conjunction with the ABA guidance will show that we do in fact have an obligation as lawyers to fully understand the relevant technology, which today, of course, is Zoom. And I'll just throw in one more thing, which is that, we've done a FINRA mediation. FINRA is great about helping out with the technology, but it's very important that you understand what's going on, because the FINRA representative is going to leave and you're going to be on there and you have to understand. And I think most of us do these days. Everyone's been on Zoom long enough that we know, but there's still suspects out there that I think are not fully competent in Zoom. And it's important, clearly, based on what we're talking about, that we do understand it, because we are ethically obligated to do so.
Well, that raises a point, though,
That
right?
is the long answer.
It's also, you have to worry about cross-border practice of litigation, making sure you're not doing unauthorized practice of law. I don't think it comes up much in FINRA mediations, but it's something out there. And I also looked into this morning whether or not there have been any suspensions, fines, or anything else for people not knowing Zoom. And it was, preliminary research, but I couldn't find anything. So either, the bar committees and whatnot have more important fish to fry, or people are really top notch on their Zooms.
I think that, we should take a look at one of the comments that just came in, and it said that, the rule really requires that you understand benefits and risk and quote unquote, not how to use. But,
Right.
if you are representing, how to use, you've agreed to set things up and you're going to be using this platform for the presentation and for the parties for the day, and you are inept at it and you wind up causing information to be disclosed and whatnot, you set yourself up for violation of other provisions. So, I would agree that the rule is right in that you as a lawyer don't have to know how to use it, but you need to have somebody there who knows how to use it, i.e. the plan for the paralegal. And if you're going forward without knowing what you're doing that day, you're really putting yourself at severe risk.
And by the way, to that anonymous poster, there are tools, not necessarily in the rules, but JAMS, AAA, FINRA, they all have webinars, videos, Q&As, frequently asked questions. So, and you can ask any of the administrators internally in those alternative dispute resolution forum to help you. You're not on your own.
Do you think that a rule like this, I understand why it exists, right? I'm not fighting about the rule. But do you get the sense that this is going to, now we've told everybody that this is what we think it is, and most people seem to agree with us. And if you read the rules, it seems to be, that scare people away from doing this? Because the one thing that gets my attention as a lawyer, and always has for 30 years, is ethics, right? If this is something that's going to affect my license, if this is something that is really meaningful to my practice, if I'm not as facile as I want to be, or I can't get that paralegal in the room, or I don't trust they're going to come back, my answer just might to my adversary, thanks for offering. I'll buy the plane ticket and I'll show up because I don't want to run afoul of the rule. Do you think this rule has like a chilling effect on what people are actually doing? I'll give that to anybody.
I think technology's always had a chilling effect on what people do, and those who can adapt to technology will succeed, and those who choose not to will find something else to do. That's all.
It's a fair answer. Anybody else? Good. All right. So let's go to hypothetical number 2. Go back to the screen. So once you connect with your client right before the mediation begins, she tells you that she plans to have her daughter and niece in the mediation to help. Ellen, you spoke about this a little bit earlier. Her daughter and niece are not parties to the mediation and have no relation to the business. You generally communicate with Mrs. Scott over the telephone and via email, and you've never met her or them in person. So we ask, should the daughter and niece be allowed to sit in on the mediation? I'll let you stare at that for a second, and then we're going to open up a poll and we're going to find out what you all think about that. So we're going to go to Q2, there's Q2, and we're going to launch it. Should the daughter and the niece be allowed to sit in on the mediation? Kindly begin voting. That's a lot closer than I thought. We'll just give it another minute. I mean, I think just as we're waiting for folks to vote, this is a difficult situation. We've done webinars on this. I think everybody in the field has, about elderly clients and elderly investors and how to make sure they're properly represented, taken care of not only by their brokers and their fiduciaries, but their lawyers. So I guess their fiduciaries as well, obviously. And I think sometimes, what's the first thing that they tell you at a broker dealer? Make sure you have a trusted contact. Make sure there's somebody that you can talk to. And so I think everyone's stopped voting. We're going to end the poll and we're going to share the results. Majority here, 60%, 61% say that you should not let them get involved. All right. So we're going to let me just get to the first code because we're coming up on 1 o'clock in the afternoon. It's not going to be a surprise, but the second one might be. The first code today is Zoom, because it's easier for you to remember, and you will not have to email me 3 days from today when I don't remember it. All right. So first code, Zoom. All right. So let's talk about then, should the daughter and the niece be allowed to sit in on the mediation? Sean, I'm gonna toss that over to you, see what you think.
Really? I thought we were going to toss over the next question to me.
I have you here as question number 2, so I'm going to ask.
But we changed the format. I'm the next question. It's Angela and Ellen. Is this one?
Oh, okay.
Yeah.
Well, look, I've allowed people to sit in on Zoom mediations, and even back and in person, sometimes, an expert witness or a trust attorney or some other person would want to be in, depending on what the issues were, and the level of, facility with the issues from the claimants and the claimants counsel. I always think, and this was true back in the day, if you put your foot down and say, no, these extra people can't come on, they might have a different agenda than the actual litigants themselves and their individual counsel. You're going to adjourn. They're going to call these people. They're going to come up with the arguments anyway. They're going to regurgitate them back, and you'll be in the same spot. So part of me says, you're better off, just perhaps allowing it to happen to a certain extent. I agree, it adds a lot more complexity to the mediation, and it's happened to me, I think, twice since I've been a mediator, and they were insistent upon it, so I just let them attend.
What do you think about confidentiality agreements with the daughters? Right? Should they be made to sign something? Just someone just asked a question. Should they be made to sign something like that to make sure that it doesn't leave that room? I don't know how enforceable it is, but I think it's a good start. What do you think about that?
Well, when you go, generally speaking, when you go to a mediation, right, all the participants have to sign, right? And then the mediator usually gives a spiel about how everything that occurs is confidential. So, you could talk about concerns about privilege, but are there really those privilege concerns when everything that occurs at a mediation is in fact confidential? So I think and just going back to what Ellen said, it seems to me that there is a lot of individuals that are much more comfortable having their family members attend, notwithstanding the fact that sometimes it complicates the mediation. It makes it more difficult to resolve it because you have the input of the husband, the mother, whoever it is. But I think it's one of those things like that the nature of the mediation is confidential. So if everybody's signing it and it's all confidential, it doesn't seem like it would be an issue. I don't know if anyone has a different opinion on that, but.
It's one of those things that you really need to address with your adversary beforehand, so that there aren't surprises, because I mean, we've all seen this over the years where it's come up even when you've been in person, where, you know, you get to the mediation and the claimant has somebody who you didn't expect to would be there, and your client turns around and wants to know why they're there, and is this fair that they're there? And, you know, just really picking up the phone and talking with your adversary about what's going to go on beforehand can eliminate those things, so you can speak with your clients. You can make sure everybody signs off on the confidentiality agreements. And in terms of, you know, on the respondent side, you know, if the claimant's counsel is comfortable having that other person there, I mean, I'm not going to turn around and argue that anything going on in there is breaching, you know, client confidentiality communications, because a stranger's there, it's their daughter. And I just don't think that will work very well.
And I think for the purpose of the, you know, we specifically put a daughter and the niece, you know, a relative into the hypothetical, because you would expect with an elderly investor or client, that's what you might get. But I think Sean brings up a really good point that, and this has happened, I've even had this happen in arbitration. You know, an older investor is the claimant, and I had a woman bring her family.
Yeah.
And when all these people rolled into the room, I, you know, had to raise my hand, because only I would ask and say, I'm sorry, I don't know who all these people are. And the answer is, well, she feels better when these folks are around her. Okay, you know, which forced me to be the bad guy and say, unless they're testifying, they're not here. And if they're testifying, they're still in the
waiting room.
hallway, right? So, you know, I think you have to look out for both. I've been at mediations where someone's brought, oh, this is my friend, you know, Bob, he's just helping me with the math. I just like him in the room when we talk about it. It'll be easier for me. I guess then you have to make a judgment call, right? As to who you want to have access to this information. So I think it's a good point. And I think I agree that that's something you really got to be clear with your client, your adversary about. And if you see something you don't expect, you really have to call time out and work it out with your client, work it out with your adversary. And I would say, get the mediator involved, because that might be the first disagreement that you might have to get through first, as to actually who sits in the room. Okay, good. So why don't we then go to question number 3. This one, I know it's going to upset you, doesn't have a poll because it's really not a yes or no answer. But don't worry, there'll be at least 2 or 3 more. So after talking with Mrs. Scott over Zoom, can you guys see that? Did I get that up right there? I did. Okay. So after talking with Mrs. Scott over Zoom on the day of the mediation, you believe that you're both on the same page about reaching a settlement of about $600,000. Client tells you, I think I'd be happy at that number. At the beginning of the mediation, you text the mediator asking if they can send you the confidential documents your paralegal sent to them the night before. You know, the paralegal doesn't work for you anymore. You want to make sure that the mediator has received the correct version. Instead of texting you back, the mediator inadvertently turns over the documents to the respondent. I'm not going to tell you that's happened to me, but it's something that might have happened to me. So then the question is, what is considered an illegitimate communication? And what should the respondent's attorney do when they receive those documents? And I just got to note that we weren't sharing. Did you guys not see the hypothetical? I'm sorry about that. But I think everybody understood it, right? So let me go back to the questions. What is considered illegitimate communication? And what should the respondent's attorney do once they get the documents? Who is fielding this question for me next?
I've got
That
this
is
one,
Sean.
Joe.
Because I had you down and I was afraid that I was going to send it to the wrong person.
Well, you know, so
Go ahead, Sean.
this is kind of an interesting twist, right? Because it's not necessarily that inadvertent communication directly from counsel to their adversary that, you know, can happen with e-discovery and our days and everything today. What happened here is the documents were given to the mediator, confidential communication to the mediator. A request was then made to the mediator to return those documents, and the mediator turned around and gave them to the other side. So if you're the other side, respondent's counsel, you know, first you got to wipe that smile off your face for getting those documents, right? And secondly, under New York law, really what you have to do is you have to notify your adversary that you've received those documents, and the onus is really on them then to turn around and how they go about collecting them back. Now, you should not use those documents. You really should not read those documents. Once you ascertain, when you saw confidential communication to the mediator from your opponent, you should stop right there and let people know what you have. But your bare duty is to let everybody know you've got them. And where lawyers then can get into trouble who have them is if they turn around and start relying upon them to, build up their examination of an expert, build up their examination of somebody else. And it can be shown that you are now relying on these confidential communications from your adversary to build up your case. Okay, that said, so what do you do? You stop reading. You probably want to, let other people in your firm know what you have, or if you're in-house, let people know that you've received this. Then you want to notify the sender. Now, in this case, what I would do is I would notify both the mediator and my adversary, because I want to make sure really the real sender here isn't the mediator, they're the conduit in my belief. But the adversary needs to know that this came into my possession. And then I think really you've got to secure that and separate it and wait to see what your adversary does. What do you guys think?
So I think it's interesting just to note in this context that in New York, it's not as clear. You definitely have to promptly, pursuant to the rules of professional conduct, you have to promptly notify the sender. But if you look at the commentary, it's not as clear whether or not you do need to return the documents or not. I think they say they leave it up to the professional, which is interesting. Personally, I think that an ethical lawyer should stop and return the documents. But what is interesting, if you look at other jurisdictions, like in New Jersey, the parallel rule specifically states that in addition to promptly notifying the sender, you must return the document to the sender, or if in electronic format, it must be deleted.
Right.
And in Florida, just because it's interesting, in Florida, you can get yourself into trouble. So if you leverage you receive inadvertently disclosed documents and you use it to your benefit, the other side, the individual that made the mistaken disclosure, can actually make a motion just to disqualify you as counsel. And they've done it. The counsel's been disqualified. They brought it up to the appellate courts. The appellate courts held it up and said, yes, we expect more from our Florida counsel. And that if you don't, you should not have taken advantage of the other side's error. So it really depends on jurisdiction, what you are obligated to do. But I think here I would do what Sean suggested, because I think that is the ethical right thing to do.
And California is similar to Florida too. It really puts an onus on the recipient of that information to do the right thing. And there are countless cases out there of lawyers getting fined, disbarred, or whatnot for using that information and going forward, as are there, in New York State, if you turn around and start using information you receive that way. So, this is an area where you just need to go about things and do the right thing.
Yep.
As opposed to living with that. Now let's talk about, let's say the mediator's not involved, right? So Ellen, you didn't give this to the other side.
And
Oh,
that
we cut
happens
you
to
out of
be
it.
true. That happens to be true.
Right. But let's say, in the course of preparing for the mediation, that paralegal who doesn't work for you anymore, instead of sending that confidential statement to the mediator, sent it to your adversary, right? As the sending lawyer, what do you do? Right? I mean,
I think that's the same place where you have to raise the hand.
you've got
Yeah.
exactly the same place. You've got to turn around, relax for a second, and then reach out to the other side and explain what just happened, and ask for those documents back.
Ask for him back.
And in New York State, once you're on notice that the documents have been disclosed to your adversary, if you want to get a protective order or anything like that, the burden falls on the side that inadvertently disclosed those arguments, because one of the first showings is going to be that was truly an inadvertent disclosure, and it wasn't something that you meant to do, and it wasn't a knowing waiver of privilege.
And I think this whole conversation comes up really because of the technology, right? In the in-person mediation, you would put together a binder for the mediator or anything like that. You'd slap a huge confidential to the mediator only on top of that binder. And if they wanted it in advance, often FedEx it would go. And you'd have one and the mediator would have one. And there was no way that he or she could walk down the hall with this thing without having that red flag on the front of it.
Unless, of
Now it's a
course-
push of a
Unless,
button.
of course, you're that paralegal sent it to the other side via FedEx, right?
Yeah, well, that could happen. That actually could happen. I used to, it depends on who the mediator was. And as the resident dinosaur in this group, I'd bring that stuff with me, pack up the lit bag, put it in the boxes, and we'll hand things out when we have to. I never liked sending anything electronically across the threshold. Sometimes you had to, but now, like you said, the last mediation I did, the mediator said to me, listen, I need to understand what's going on here. Can you give me things that I will not share, but it will give me context? And I would imagine, Ellen, you'd agree that context is really important in some of these cases. And some of those documents that they're not going to share really will show them, the right or the wrong side of the line.
Right.
think
And
we
I
come
just
back
say,
to
as
it.
just sort of as something that I do, I of course, read all the things that have been sent to me, pleadings, mediation submissions, et cetera, mark them up, have a million questions to ask both sides. But then during the actual mediation, I have a separate legal pad where I list down specific, bright line down the middle of the page. On the left is what so-and-so party gave me. On the right, check or X, may I disclose to the other side. So I
Right.
take that really seriously and try to be, and I hope achieve, complete crispness and professionalism on that issue, because it really could drive the decision as to whether or not to settle, and if so, at what cost.
Okay, thanks,
Someone just
everybody. Let's,
Someone just
oh.
commented, if a mediator turns documents over to the wrong party, they need to find a new profession.
yes, that was a great comment. I'm sorry that I didn't read that out. You are all correct in that. All right, so let's go back to our third question of the fourth, excuse me. There will be a poll for this, so get your buzzer fingers ready. By the afternoon of the mediation, you are coming close to a favorable resolution. What a lovely thought that is. It's 4 o'clock and I have a 5 o'clock flight. Let's get this over with. However, you're noticing that Mrs. Scott seems tired and is not understanding the process of the mediation. You are not fully convinced that she understands what's going on, but based on the earlier conversations, that she's looking for a $600,000 settlement. It should not be a surprise that our next question is, are you ethically obligated to stop the mediation when you realize Mrs. Scott is tired and struggling to understand the decision, but you believing, and now I'm ad-libbing a little bit, that you know what she wants, because she said she might like 600,000, can you ethically continue? So let us run the poll on that. I want you to give it a thought for a second. And we're going to go to Q4. And here we go. It's either yes, you need to stop, or no, keep moving. All right, let's see what the audience wants. When we have more money next year, we will be playing the Jeopardy music, but we were a little tight this year for funding. All right. Once again, there seems to be a tremendous outpouring of, you need to stop this. And we're going to share it in a minute. I want to give everybody a chance. All right. The meter seems to have slowed. So here we go. Here are our results. 78% tell us that you need to stop the mediation. Angela, are you stopping the mediation?
So I think under these circumstances, while your client did say she would like $600,000, that was earlier in the day. And it depends, I guess, on a lot of what has transpired, but it comes down to the operative phrase, informed consent. So under the model rules and the New York Professional Rules of Conduct, you need to have the informed consent of your client before you embark on any strategy, agree to any settlement. And now that the end of the day has come and your client is an elderly person who, if you know anybody that's elderly, they can be lucent, for the morning, and then the afternoon comes and suddenly they're confused and don't know what's going on. So the question remains, do you have their informed consent at this point if they're having issues understanding what's going on? So just from the basic facts we have in this fact pattern, and if your client doesn't seem to be understanding what's going on, I think you need to take a step back and perhaps discuss with the other side whether you do need to maybe adjourn the mediation so you can make sure you do have the actual informed consent of your client. Obviously, if they have a diminished capacity, or some kind of, even if it's temporary, that consent may not be informed. And that's what's required by the rules of professional conduct. And there are also rules that are specific to diminished capacity. Model Rule 1.14 talks about client with diminished capacity. The lawyer must maintain a normal client-lawyer relationship with the client. And when the lawyer reasonably believes that there is a diminished capacity, they must take appropriate steps, whether that is, in this case, I don't know what steps you're taking, but it is something the model rules is focused on. And just to make on a related note, not exactly on point, but, over the last 10 years, there's been an uptick on the focus of the protection of senior investors. Every state has an adult protective statute. Many states, I think 37, have financial exploitation statutes, and these are applicable to financial services representatives. But I think it just makes the point that there is the reason why these rules exist is because there is an exploding senior population. And there's a lot of individuals getting older and older. And we as lawyers need to be cognizant of that and be cognizant of our clients and their abilities to understand what's going on. So the long answer here, that was my long answer, but the short answer is that I think that you do need to take a step back and possibly adjourn the mediation until your client has rested and has a clear mind. I don't know if other people have thoughts on the topic.
Well, just on that thought of people getting tired, the second code word, not that you'd leave 15 minutes early because I gave you 15 minutes early, is fatigue. So your two code words are Zoom fatigue, which hopefully you don't have just yet. And we only have 15 minutes left, so you should all survive. I want to keep moving, but if anybody has any quick thoughts on that, Ellen or Sean, I'd be happy to.
Just real quick, I mean, I know words have meaning, and I think in the hypothetical, this is obviously more of a claimant's attorney-centric kind of question, because the ethical obligations Angela discussed really pertain to that attorney-client relationship. But the word, I think I'd be happy at 600,000. That could change. Thoughts change. You learn something in the course of a long mediation day. So I don't think the claimant's attorney under the rules would be permitted to rely on that expression of interest at the beginning of the day and not acknowledge the tiredness, the confusion, the fatigue.
Right, 100%. That's what I'm saying. Things change throughout the day. You don't know if she's still happy with 600,000. So.
Okay. Last word, Sean.
The other person too, I think, is we were talking about this during one of the prep sessions is, are the respondents people engaged as well? Because this happens both ways, and we have to be mindful that we might also have, a client who is older, who is disengaged, and we need to make sure if we are making a settlement on behalf of those clients that they also understand what's going on. So the informed consent portion, yes, the person receiving the money needs to understand and agree to getting that money, but you also need to make sure the people paying the money are also informed and consenting to what's going on there. And over the years, and I think sometimes it's more difficult in the Zoom format because business people will show up and they're there working with you, but they're also doing a whole bunch of other things because many of us have learned how to micromanage and multitask during this Zoom thing and maybe not give the concentration that's needed to understand what's going on or to understand why it might make sense to settle a case.
Okay. I did not do my job well at giving out the second code word because I keep getting questions about it. So the word is fatigue in the present as opposed to fatigued in the past. It's Zoom fatigue. The judges will accept either on your reform. Okay. So let's get to the fifth question of the hypothetical as follows. Meanwhile, the respondent's attorney learns that her paralegal, I think we're weighing a lot on paralegals today, and I might hear about this when it's over.
As a mother of a paralegal, I am cringing every time.
The respondent's attorney learns that her paralegal has been recording some of the mediation, clearly without telling anybody else about it. When confronted, the paralegal claims that he's been recording because it will help him emulate good lawyering, but the respondent's attorney still feels uneasy about it. All of these iPhones record, and in the old days you had to tape a tape recorder to the bottom of the desk. Not that I ever did that, but now everybody's got a phone in their hand and they can record. So that brings us to question number 5: is the respondent's attorney ethically obligated, and that's the punch point, to disclose that the paralegal was recording. I'll read it one more time before I pull it down. Is the respondent's attorney ethically obligated to disclose that the paralegal was recording? I kind of get the sense that we know what the answer is, but everyone likes a good poll. So we're going to do it one more time, and that's going to be question 5, and we're going to launch it. And here we go. You're off. Let's see what you say. I love the fact there are people out there saying no. I just think that's great. There's only one of you so far, but I think that's very cool. There's one. Oh, there are 5 rebels in the group. I don't know whether or not the participants can see the scale until we're done. I think they have to wait, right? They can't see this
They can't see it
speedometer.
until we're done.
Yep. Okay. So we're getting tight on time. I'm gonna end it now, and I'm gonna the results are what I think we thought they would be 88-94. Sean, are you answering this question today?
No, Angela is. I'm answering.
Angela, are you answering this question today?
Not my question.
All right. Ellen, are you answering this question today?
I have it down as Angela, but I agree with the pollsters that
Yeah,
yes,
I don't think we need a script to answer this question. But go
yeah.
ahead.
had I been able to vote, I would have voted with the yeses.
Okay. So having done a little research on this myself for the following reasons. So every state's got a different rule on who can record and what they can record and how they can record it, right? So there are one-party states, there are two-party states, but that's not really the issue here, right? So we're not seeking to admit any of this in court. We're not seeking to work on behalf of the state. But the question is this: there's information that is supposed to stay in the room that now has the potential of walking out of the room. It's just that simple.
Yeah.
So we all are clear on what documents are confidential. We just spent 10 minutes talking about that, right? We're clear on that everything we say among ourselves. I'm sure, Ellen, that's part of your opening salvo to everybody. But now I've got somebody in the room, with a recorder. So I think the ethical obligation here is, despite what state you're in, right? What you should be doing is, number one, besides chastising the employee, is making sure they erase it and destroy it in front of you, and then tell everyone that you've taken those steps. I don't think that requires a lot of thought. But I think it's important because this is one of those things, again, in the world of technology. I teach part-time, and I noticed in my, I don't know, I guess maybe 2 or 3 or 5 years ago, that someone had an iPhone just sitting on their desk. And I said to them, "Are you recording this?" And they said, "Yeah." And they didn't think twice about it, right? They didn't think twice about it. And now I live in a world where they record all the classes anyway, so it doesn't make a difference. Some people might not think twice about it. So I think, Ellen, you might consider, in your opening remarks, reminding people that recording things, even for the sake of, well, it's just for my notes so I remember what was said, is something everybody has to agree with.
Yep,
All right.
it's in my agreement.
I will just
Okay.
add that it's interesting that the ABA, actually, there's an opinion that states that the ABA, a lawyer who electronically records a conversation without the knowledge of the other party to the does not necessarily violate the model rules. So the ABA sort of doesn't take a position on it, but
Yeah.
they go on to say that you have to follow the rules of your jurisdiction. But I do agree that it just seems a little odd to just start recording conversations and not letting anyone know. But you would think the ABA would take a position on that, but
Yeah.
they do not.
I mean, it's just something that smells bad, right?
Right.
So the recording's going on, you find out about it, right? I think you need to tell the other side what was going on. You need to tell the mediator what's going on. And then you need to take the steps to resolve that. And I think you really need to almost, verify that recording has been deleted.
Yeah.
And it, otherwise, it's potentially out there. And I think it just violates the confidentiality nature of the proceeding. And I think it really hurts your client as well, because if you think about a mediation, you're in there with your client, you're going through, the facts of the case. Those should be privileged, confidential communications. And you just got to be mindful of maybe not necessarily things paralegals do, but let's say it's an intern or summer associate, something like that, who's trying to learn about this for the future. Just make sure that doesn't get done.
Well, and I think I understand that you say you put it in your agreement. And now this is food for thought for the next time I do a mediation, is that I'm going to ask that everybody, be reminded that there's no recording of anything. It might be just an easy way to get that out of the way. Okay, so let's, we have 7 minutes to go. Let's get to our last hypothetical.
It's not me,
It's not you, Angela.
not
No.
me.
Now, I have it as Ellen.
It's me.
When
It's
did
him.
everyone change the assignments?
I'm
Did I
telling
miss
you, I
a
was 1 and
call?
4.
Did I
was
miss
1
that
and
meeting?
4.
All right, the audience will not have to suffer through us bickering, but we will discuss this later during our roundup. All right.
All right.
Hypothetical question 6 of 6. At the end of the day, while you and your client are speaking with the mediator about the final settlement amount, the client's Wi-Fi goes out. Of course, the client's Wi-Fi goes out. You continue with the mediation. You tell your mediator your client will settle for $600,000. Now, that's a dangerous thing to do based on what we've talked about. The mediator agrees, and you're sent to another breakout room. When Mrs. Scott gets her Wi-Fi back, probably because her daughter told her to turn it back on, you happily share the news that the mediator agreed to a $600,000 settlement amount and has brought, I'm adding, and has brought that across the hall, so to speak, electronically. Mrs. Scott gets upset. No one's ever confused whether or not Mrs. Scott is upset, claiming that she never agreed to the previously discussed $600,000 settlement amount. So those 50 seconds when the Wi-Fi wasn't working, you now have a client who's going to make you go back and do something. And the question is, what should you do? Number one, when your client's Wi-Fi goes out, should you continue with the mediation? And what do you have to do now that she has rejected the offer? Obviously, we can't pull that either because those are 4 questions, 3 questions in one. So who did we agree was going to do this?
So I was going to do this.
Okay, you have 4 minutes.
Oh, great.
Oh.
So first off, Wi-Fi going out is something you should have talked to your client about beforehand. And you should have gotten permission in writing that you documented with that client about what you can do in terms of negotiating without them. Okay. And if you didn't do that, you weren't doing your job right. Let's say you did that though. Do you have an understanding? Have you documented that understanding about that $600,000? Do you have written, do you have authorization to accept that as a settlement demand? If you do, it's one thing, but even under there, the client has a right throughout to turn around. They might have given you, authorization to accept $600,000. That at the end of the day, before you've actually said yes, and before it's all papered, said, no, I don't want to do that. And if that's the case, the client controls things. Okay. And if you have to put your, hat in your hand and go back and tell the mediator, I didn't have authorization to do that, then you have to do that. And it's really that simple. You're working for the client's not working for you. You guys disagree with me?
Not at all, but not at all, but the other wrinkle to this, if you wanted to extend this hypothetical, one more chess move is, did the mediator communicate the acceptance to the other side?
Right.
Now that's like a big mess.
Big mess.
Well, but the reality is this, right? And I hate to sound like a lawyer. Until somebody signs on the bottom line, nobody's bound to anything, right? So if you have to
sign on the bottom line and the checks are cut.
Right. So I have been in the position to go back and say, listen, I'm sorry, but we've had a change. And I've heard that from the other side too, right? And I think the one thing I would consider here is, so we ask you, what if the Wi-Fi goes down? If her phone still works, that will get you out of this mess. I think there is some tunnel vision here with the technology where, right, the Wi-Fi goes out, now I can't talk to her. I don't know, when we were doing mediations back in the Stone Age, how did we talk to business people? How did we talk to people who had the check writing privileges at the bank we represented? We picked up the phone.
A purse full of quarters.
They took the last payphone out of New York City 2 weeks ago.
Smoke
They-
signal.
Heard that. I heard
Yeah, they
that.
pulled it
No,
up
they
off the
did
street.
not.
It's going to go
That's
in a
not
museum.
true.
It's not true?
Yeah, they went on the news and said they did it, but I have since found like 5 payphones because I'm now on a quest to put the media in its place. Anyway.
There's one in the Oyster Bar, by the way. Grand
Uh-huh.
Central. Go ahead, Angela, outside of our.
No, I was just going to say that you
Little
said
choices.
until they signed on the dotted line, there's no deal. That's not necessarily true. Like
Tell me.
if there's a deal in principle and they haven't signed yet, there's plenty of case law, especially in New York, that says there's a deal and you can move to enforce the settlement, but that's a whole other story.
That's where it's been papered. That's where there's been exchange of written documents on it.
Right, like an
Not-
email.
not
yeah,
where it's
exactly.
been.
Right.
uh,
I've seen cases where there was an email where both sides agreed to terms, and there was a reasonable representation of a meeting of the minds.
Yep.
I absolutely.
I've
have seen-
I've had a case just recently where we had to make efforts to enforce it because that's exactly what happened.
That's what happened.
Yeah.
All right, we have a minute for Q&A. But I don't see any other questions and I don't see anything in the Q&A. We have hit 1:30. I want to thank everybody who participated. I want to thank all of our attendees. We're at, it looks like 130 attendees. So I thank you very much for giving us an hour of your time on a summer
We had
afternoon.
more before you gave that second code, Joe.
I think it was close. I honestly think it was close. I also, and I have a note on my screen. I want to thank Kate Capizzi. She is our summer associate who
Thank
did
you,
all the research on all the answers to all of these questions. I'd like you to think it was us, but I'd be lying, and I'm pretty sure that you know that I am. So we will all be sending out the compendium of rules and answers that we gave you today to our participants. If you were registered today, you're going to get a copy of that. Certainly, you have all of our contact information. If you need to reach out to us, we will be happy to do so. And let me just make sure someone once again, asked where are the 5 payphones? We'll have to do that another time. If we can make a CLE to 5 payphones in New York City, I will. And the code words again are Zoom fatigue. And on that note, I will thank all of you.
There's one at 77 Water Street.
Here, I will
Oh,
thank all
wow.
of you for coming. Have a great day. We'll see you soon.
Bye-bye.
Bye,
Is there any
everybody.
music?
Thanks for
That would be
joining us.
better if there was like pull out. I don't think there is.
All right.